If you're over the age of 65 and at some point you've added one of your adult children or another family member onto your bank account to make things easier, I need you to stay with me for the next few minutes. Because one of the most common things people do to simplify their banking later in life can quietly do the opposite of what they intended. I'm not talking about a small inconvenience here. Depending on the state you live in, this one decision can expose money you spent decades saving to someone else's lawsuit, someone else's divorce, someone else's bankruptcy, and it can change who actually receives that money when you die, regardless of what your will says. There are three specific things this one decision can quietly do to your money. Three things. And then there are two simple alternatives that give you the same help without taking on any of that risk. Here's the part that genuinely surprises people. This isn't some obscure loophole or a rare edge case. It's written in plain language in the Consumer Financial Protection Bureau's own guidance for people helping a parent or relative manage money. Most people simply never see that page because nobody hands it to you when you're standing at the teller counter, adding a name to your account. And I want to be clear about what's actually happening here because I think it's the single most misunderstood part of bank account planning for people our age. Adding someone's name to your account so they can help you does not work like a power of attorney. It does not work like a will. As far as the bank is concerned, that person isn't a helper. They are a legal co-owner with equal rights to every dollar in that account, starting the moment their name goes on the signature card. This matters because it's an extremely common move, not a rare mistake. Adding a trusted child or relative to a bank account is one of the single most frequent things families do as parents get older, almost always with good intentions, to help pay bills, to make sure someone can step in during a hospital stay, or just to avoid paperwork down the road. The Consumer Financial Protection Bureau built specific guidance around exactly this situation, precisely because so many families run into the same problems after the fact. And this isn't only about adding a son or daughter. The same risk applies if you've added a niece, a longtime friend, or a caregiver. It applies whether you're managing this on your own or whether your spouse has already passed and one of your children has stepped in specifically to help you. It applies if you have one child nearby and two who live out of state, which is exactly the situation that leads most families into this setup in the first place, simply because convenience usually wins out over a longer conversation about the right legal tool. It also doesn't matter whether that person ever does anything wrong. Even if they're completely trustworthy and never touch a cent they shouldn't, simply being listed as a joint owner still controls what happens to that account, both while you're alive and after you're gone. The risk isn't about your family member's character. It's about what the paperwork at the bank actually says, regardless of what everyone agreed to in good faith around the kitchen table. Point 1. Creditor and lawsuit exposure. When you add someone as a joint owner, you're not just giving them access to help you. Legally, you're giving them ownership. That means if that person is ever sued, falls behind on debts, or owes money to a creditor, the funds sitting in that jointly owned account can become part of what a creditor is allowed to go after, because on paper, it's just as much theirs as it is yours. Think about how this plays out. Say your daughter is added to your savings account to help you manage things, and a few years later, she's named in a lawsuit over a car accident, or falls behind on a business debt, or owes back taxes. A creditor who wins a judgment against her can typically ask a court for what's called a garnishment, a legal order that lets them reach into a bank account and take money directly out of it. If her name is on your account as a joint owner, that account can become a target simply because her name is there, regardless of whose paycheck or pension actually built that balance over the years. This varies by state, and it depends on details like exactly how the account is titled and who deposited the funds. Some states give more weight to where the money actually came from. Others look mainly at whose names are on the account. But the basic exposure is real, which is exactly why elder law attorneys consistently warn against the setup. The simple action here is to find out today exactly how any account you currently share with someone else is titled at your bank. Ask the branch directly. Is this a joint owner arrangement or something else? Ask for the actual account agreement, not just a verbal answer, since that document is what a court will look at if it's ever in question. Point 2. Divorce exposure. If the person you've added is married and that marriage ends, money in an account they legally co-own with you can sometimes become part of what gets divided in the divorce, depending on your state's rules around marital property. Some states are what's called community property states, where assets connected to a marriage tend to be treated as shared. Others use a different standard called equitable distribution, which looks more broadly at what's fair to both sides. Either way, a joint bank account with your name and your child's name on it is exactly the kind of asset that can show up in a divorce attorney's discovery requests, the formal process where each side has to hand over financial records. You added that person to help you pay your bills. Their ex-spouse's attorney doesn't see it that way. They see a joint asset with your child's name on it, and they're going to ask questions about it. Not only does this expose your money to someone else's legal troubles while you're alive, it also means a decision made for the sake of convenience can pull your life savings directly into a stranger's divorce proceedings, with both sides' lawyers arguing over money that was never meant to be split between anyone but your own family. If you ever do keep a joint account with someone for other reasons, keeping clear dated records showing the money was originally and entirely yours can help if the situation comes up. But the cleanest fix is avoiding the joint title in the first place, which is exactly what points 4 and 5 are about. Point 3, and this is the one that causes the most damage inside families: survivorship. Most joint bank accounts are set up with what's called a right of survivorship. That means when one owner dies, the full balance of that account passes automatically and entirely to the surviving owner, not according to your will, not split among your other children, automatically by law the moment you pass away. Picture a fairly ordinary situation. You have 3 children. You add one of them to your checking account because they live closest to you and help you pay bills. Your will says your estate should be split evenly between all 3, but that checking account isn't part of your estate anymore. It belongs in full to whichever child's name is on it the instant you're gone, even if your will says otherwise, and even if that was never your intention. Here's a second version of this that comes up just as often. Say you remarried later in life and you added your current spouse to your account, while your will leaves a share of your overall estate to children from your first marriage. If that account carries a right of survivorship, your spouse can end up with the entire balance automatically, and your children from your first marriage may receive nothing from that specific account, regardless of what your will says about your estate as a whole. This exact pattern, a joint account quietly overriding a will, is one of the most common sources of estate disputes that attorneys see, especially in blended families. A decision made years earlier, purely for convenience or for a second marriage, can end up overriding your entire estate plan for that one account. And it can start a fight between siblings or between a spouse and adult children that has nothing to do with how much you loved each of them. It happens because the account itself was never actually part of your estate to begin with. It transferred directly outside of probate the moment you passed. Before we get to the fix, one quick thing worth knowing, because people sometimes assume joint accounts are risky for a completely different reason: deposit insurance. That part actually works in your favor. The FDIC insures deposits based on what's called an ownership category, and a joint account is its own separate category from an account held in just your name. Each co-owner of a joint account is separately insured up to $250,000, which means a 2-person joint account could be insured up to $500,000 combined at the same bank. So insurance coverage isn't the problem here, and combining accounts with someone doesn't put your deposit insurance at risk. The problem is ownership, creditor exposure, and inheritance control. Which brings us to what you can do instead. Point 4. Ask your bank specifically about a convenience account, sometimes called an agency designation. This lets a trusted person sign checks, make deposits, and handle day-to-day transactions on your account without making them a legal co-owner. The money stays entirely yours. It isn't exposed to their creditors or their divorce, and it doesn't carry any right of survivorship, so it can't override your will when you die. The Consumer Financial Protection Bureau specifically recommends asking for this by name because many bank employees either don't mention it or aren't fully familiar with it themselves. So when you go in, say exactly this: you want an account where the money stays yours, with someone added only to help with transactions, and you do not want that person to have a right of survivorship. If the first person you speak with doesn't know what that means, Ask for a branch manager since this is a real product most banks offer, even if frontline staff don't always lead with it. There's also a related but different tool worth knowing about, especially for investment or brokerage accounts, a trusted contact person. This doesn't give anyone access to your money at all. It simply gives your financial institution someone to call if they notice signs that you might be getting scammed or exploited. It's not a replacement for a convenience account or a power of attorney, but it's a free, simple safety net worth adding on top of whichever option you choose. Point 5. For anything beyond basic day-to-day help paying bills, managing investments, or handling things if you become unable to for a while, talk to an attorney about a durable financial power of attorney. This names a trusted person called your agent to manage your finances on your behalf without ever making them a legal owner of your money. It doesn't expose your accounts to their creditors or their marriage. And unlike removing a joint owner, which can sometimes require that person's cooperation, you can revoke a power of attorney at any time for any reason, as long as you're still able to make that decision yourself. That's exactly why the Consumer Financial Protection Bureau's own guidance for financial caregivers tells agents acting under a power of attorney to avoid joint accounts entirely and to keep your money titled in your name, not theirs. One more decision your attorney will walk you through is when you want this power of attorney to actually take effect. A durable power of attorney can be written to take effect the moment you sign it, which some people prefer for simplicity. Or it can be written as what's called a springing power of attorney, which only takes effect once a doctor confirms you're no longer able to manage your own decisions. Either way, durable simply means the document stays valid even if you later become incapacitated, which is the entire point of having one in the first place. Here's a detail that genuinely surprises people, and it's worth knowing in advance rather than finding out the hard way. Banks don't always accept a power of attorney smoothly, even a perfectly valid one, because they're cautious about fraud and elder abuse. The single best way around this is to take the signed document to your bank while you're still healthy. Ask them to keep a copy on file, and ask exactly what they'd require to honor it later, including whether a springing power of attorney would need a doctor's letter. It's also worth telling other family members and your financial advisor that the power of attorney exists, so they know who's authorized and can spot a problem if anyone ever tries to use a forged or outdated version. None of this is difficult. It just works much better done in advance than during an emergency. Now, to be fair, joint accounts aren't always the wrong move. Plenty of married couples use one shared joint account for household finances their entire lives without any issue because both spouses genuinely intend to fully co-own everything together. There are also specific situations, like certain small family businesses or some blended family planning, where an attorney might still recommend a joint structure on purpose, with everyone's eyes open to exactly what it means. The risk we're talking about today shows up specifically when an account is added for convenience with one person intending to stay the real owner, while the other is only meant to help. That mismatch between what you actually intended and what the bank's paperwork says is where the damage happens. And because the exact legal details shift from state to state, this is genuinely worth a short conversation with an elder law attorney where you live, not just a video like this one. Let's bring this together. Adding someone to your bank account as a joint owner can expose your money to their creditors. It can expose your money to their divorce. And it can override your will entirely, sending the full account to whoever's name is on it the moment you die, regardless of what you intended, even in blended families where that's the last outcome you wanted. Instead, ask your bank specifically about a convenience or agency account for everyday help, and add a trusted contact for extra protection. And talk to an attorney about a durable financial power of attorney for anything bigger than that, then take that document to your bank in advance before you ever actually need it. If you want to read this directly from the source instead of taking my word for it, search for the Consumer Financial Protection Bureau's page on considering a financial caregiver, along with their Managing Someone Else's Money Guide for agents under a power of attorney at consumerfinance.gov. That's the same federal guidance banks themselves are supposed to be following. The underlying rules here don't change often, but how banks apply them and how families run into this comes up constantly. A lot of people are sitting on exactly the setup we just talked about without ever realizing it. I cover situations like this regularly, so if this was useful, staying subscribed means you won't miss the next one.